Good morning, ladies and gentlemen, and a very warm welcome to the 2020 Quadrant Chambers annual Energy Disputes event. The world has changed quite a bit since our last Quadrant Chambers Energy Disputes event, for reasons that no one will need reminding of. And that's reflected in our event today being online as a virtual hearing, but is also reflected in some of the themes that we're going to be tackling in this event. I'm Simon Rainey QC of Quadrant Chambers, and I'm delighted to be chairing a first-class panel of speakers, all in their own way, absolutely at the coalface of handling energy disputes in the light of new and continuing challenges. Because while COVID-19 and the effects of it commercially, legally, on dispute resolution, the sort of disputes we're having, the sort of contractual issues we're having, is the dominant topic in people's minds, it's merely an overlay of a new problem, or a new type of problem, over existing pressing issues which continue to face the energy industry at all levels. And so today's event looks not only at COVID-19 issues, both commercially and in the context of handling disputes, but also at the pressing concerns of environmental issues and environmental claims. COVID-19 has had many strange effects, both expected and unexpected, and I think one of the many effects which COVID-19 has had is it's accelerated the focusing of attention on the role of big energy in the environment. The Extinction Rebellion protests of 2019, whatever you think of them, which seem to be coming back to life again now, seem to be underscored by the practical demonstration of the effects of lockdown in reducing energy consumption and energy consumption activities, and showing possibly a faster path to alternative means of doing things we've done before, using types of energy which we've used before, and to cleaner solutions. The new world and the new normal post-lockdown may look very different. One good thing about virtual seminars, for the chairman anyway, is that we get far more questions. You don't need to put your hand up in front of a crowded room and speak your mind. You can just send us a question. Please do send as many questions as you want using the question and answer button at the bottom, and we will tackle as many of those as we can at the end of today's talk. So our first talk is recent issues arising out of the COVID-19 crisis. And we're going to therefore hit the ground running. And we're very fortunate to have as our guide to these issues, Katy Hanks. Katy is legal counsel at Trafigura and has been since 2018. A long track record as in-house counsel with Shell from 2013 to 2018. And so she's been responsible for handling the whole wide variety of commercial activities and legal problems which come up all over Trafi's vast range of activities. And so you can imagine she's been very much at the sharp end when COVID-19 broke and the first trickle of queries from anxious trading desks began to land in her email inbox from February 2020. And Katy's going to be looking at the whole picture, the legal issues that are coming up most commonly, and then she's going to be homing in on certain particular areas, charter parties, sale and purchase, and finance. And she assures me she's going to be able to do all of that in 12 minutes. Good luck. Katy.
Thank you, Simon. Good morning, everybody. Thank you very much for the kind introduction, Simon. And as Simon says, I'm legal counsel for Trafigura. For those of you who don't know Trafigura, we are one of the largest physical commodities trading groups in the world. Approximately $180 billion of revenue each year and trading volumes in oil and petroleum products of around 5.7 million barrels per day. This is my broad agenda, which I won't dwell on long because Simon's just given me an excellent introduction. And this is the global picture, a summary of what we've seen this year. Again, I don't intend to dwell long on this, but key things for us were the initial queries that arose in February 2020. Predominantly from our chartering teams actually, about whether or not they could call at various ports still. And then we really saw a change in April with the OPEC Plus agreed output cuts and the West Texas Intermediate crude price dropping below zero for the first time. And that really did give us an exponential growth in queries almost overnight. So what I really want to focus on today is the in-house perspective on all of that. Impossible to cover everything or cover anything in particular detail with this slot, but hopefully what this talk will give you is some insight into how it's been in-house, how we've managed things, the issues that have come up, and I guess the way forward to the extent any of us knows that at the moment. So there are some general themes that arose this year. Binding contracts, did we have one? Were we or a party going to be an anticipatory breach if we behaved in a certain way? We looked at existing contracts versus new contracts and the approach and response that could be taken in relation to each of those. Force majeure and frustration are topics that have come up in enormous detail for good reason in many of the law firms' briefings, but they were a recurring theme for us too. And many of those briefings were incredibly helpful to us when we were thinking about how to deal with them. And then in some cases, we also had economic hardship clauses or clauses to equite, and we had to think about whether or not they were engaged, and if so, how to deal with them. So one of the things that was interesting for us from an in-house perspective was really did we deal with the new way of working? So for those of you who've got any experience of working with trading houses, or perhaps have done a stint in-house at one yourself, you may know that a lot of what we do is dealing with walk-up queries. So people popping by your desk, they want to run a question past you, they're really keen to get your views on something, and you pick up an awful lot of information just having a coffee with someone by the water cooler, you know, informal chat. And all of a sudden, in March, mid-March this year, the Geneva office started predominantly working from home. And that made things much more difficult for us. We had incredibly good support from our IT team. That was very smooth, in fact. But all of a sudden, we lost that informality. We lost that ability to just take someone aside and have a 2-minute conversation with them. And we had to think of ways of working around that. Our internal communications changed. We had to use much more WhatsApp, instant messenger, email. We had to get used to using a wide variety of online meeting forums, Teams, WebEx, Zoom. And that was a really difficult shift for us, actually, in some ways. I think we responded to it incredibly well, but it was interesting for me how much of a difference that did in fact make. I think some of the other themes that it's worth drawing out generally are that we do get quite a lot of preliminary queries. So people coming to us on a preemptive basis where they say, I've got this contract, if this happens, what about this? If that happens, what about that? And because of the vast influx of queries that we experienced and this huge growth of legal questions, we had to really think about how were we going to respond to that? Did we have the resources to respond to those on an individual basis? Or in certain circumstances, could we give more generic advice? And I won't pretend that any of our trading queries have been life or death, but I did feel at certain times it was a bit like an A&E department. We were having to run a triage system to try and prioritise between our internal clients. And there were some cases where we felt we were able to give more generic advice or just say, these are the issues you need to think about. But we also had to be careful because it would take a while to reach that or that place where we could give that consistent advice. Because as you can imagine, we've got lots of individual traders who want to take a particular position on a given contract, but that has to be balanced against the fact that their colleague wants to take precisely the opposite position on another contract, depending on what the commercial terms are and where we sit in the contractual chain. So there was a lot of dialogue going on remotely about what position did we want to take. Were we happy to take different positions under contracts? Did we need to reach a balanced position? And that involved senior SCEDs taking a view for the team as a whole. But it also meant that there was always going to be an exception to the rule. Trading business is hugely driven by commercial relationships. So it's not always possible to take a consistent approach with every counterparty because it depends on your contractual bargaining power, the history of the relationship, and the importance of the relationship to each party. So so many competing interests, and it was interesting trying to work out how best to balance those. What I'm going to do now is actually move on to 3 types of contracts or 3 areas of the business, as Simon says, charter parties, sale and purchase contracts, and financing, and just give you some examples of what we faced and how we dealt with that in each case. So if I start with charter parties, as I say, this was really the area where we first saw the queries coming in, primarily because it's so immediate. On the chartering side, we were saying, well, can we still instruct our owners to call at these ports? What happens if we call at this port and then the crew gets COVID? Are we liable? Are owners liable? And we actually have the position where we charter in and we charter out. We charter in on a time charter, we charter out on a voyage charter. So we might have some discrepancy there between our position coming in and our position going out. Sometimes we just charter in. So what do we want as a voyage charterer? And we actually have two different chartering desks here. We have a dry bulk chartering team and a wet chartering team. And the commercial parameters in which those teams operate are often quite different, such that they might be able to negotiate quite a different allocation of risk depending on who their counterparty is and what vessel type it is. What we saw initially coming in were questions around, as I say, orders that could be given or refused, and what the rights were if it was impossible to call at a port and an alternative had to be nominated. And that was very difficult for us to give any kind of generic advice. It had to be dealt with on a case-by-case basis, which was part of the reason for the exponential growth of the queries that were coming in. What we could do is look at a difference between the position under existing charter parties, many of which typically had a force majeure clause, or for example, an epidemic or infectious diseases clause, and consider whether COVID came within those provisions. And there was a differential between the position prior to the World Health Organization declaring this to be a pandemic and the position afterwards. We also then had to consider, well, what do we do with new charter parties that we're entering into? For example, force majeure clauses are often not engaged if an event is unforeseeable. So we can't really then rely on a force majeure clause. Do we need something specific to COVID? And we spent a lot of time with the heads of the two chartering desks saying, well, what do you want to achieve? Do you want a clause when you're owner and a clause where you're charterer? Do you want a clause where you're happy to accept it in either position and have it on a balanced basis? And as I say, the two teams weren't necessarily aligned in their approach. So we actually ended up having to have a set of clauses for one and a different set of clauses for the other, although broadly based on the same principles. And then we had to make sure that the wording was clearly enough drafted that everyone was clear what the position would be in particular circumstances. So that took up a huge amount of team time and was very much a legal team effort. No one person was responsible for that. And ultimately, of course, it comes down to an allocation of risk and commercial bargaining power. What do we want and what are our counterparties prepared to accept? So even where we had our wording, we then still had some variables around whether we would have to revisit that or accept another counterparty's wording where they held the balance of the power in that relationship. Moving on to sale and purchase contracts. Again, here we tried to, as much as possible, give some generic guidance because our traders are on the phone to their counterparties all the time and they can't wait necessarily for us to respond on particular points. We said to them, really, what you need to start looking at for your purchase contracts is what are the underlying causes of non-performance if that's what's being threatened or in fact has happened. We need you to take some responsibility for knowing your contract too. Come to us with your contract, have a look at it, look at any limitation of liability provisions, events of default provisions, termination rights, change of laws provisions, force majeure provisions. Do you have a hardship clause? Do you have a clause de equite? And come to us with your particular queries about those. The hardship clauses were particularly difficult because they're a bit more unusual and they were specifically drafted, and often they arose in contracts which weren't necessarily governed by English law, but under civil law jurisdictions, and therefore there was a question about what provisions of the civil code might be incorporated, and we had to work with external counsel on those. But broadly, there was this question about whether or not it was an unforeseen and unforeseeable event, and whether that in and of itself had disrupted the economic balance of the contract, rather than it just being a bad bargain for whichever party was trying to rely on it. Again, we had this differential between contracts entered into pre and post the advent of COVID and pre and post the question of whether or not it was a pandemic for the purposes of the World Health Organization. And we also had to develop COVID clauses that went into new contracts going forwards and discuss with the business whether that would work in their favour or their counterparty's favour to include those or not. The primary piece of advice we ended up giving a lot of our colleagues was, look, be careful in your communications. Be clear when you're offering something on a without prejudice basis. Be clear when you're reserving your rights. Don't make a firm offer in writing unless you're absolutely sure that's what you want to achieve. And if you are trying to ensure that something is contractually binding, come to me and we'll have a conversation about that. And the other thing that we had to say to people is wherever this involves a prepayment, and we do a lot of those where we lump sum prepay for offtake over a period of time, then that should always be discussed with legal, because if you waive your position in respect of one delivery under that prepayment, you could be adversely impacting your ability to recover those funds or your ability or your rights to perform in relation to performance in respect of future deliveries under those contracts. And moving on a linked basis to financing, the prepayments were a key part of this actually. We do a lot of prepayment contracts, and so we had to discuss with our colleagues whether or not they were prepared to amend the terms of prepayments where producing counterparties were struggling to meet their contractual obligations, for example, because they faced a shutdown due to quarantine. And there was a lot of discussion about whether or not the non-performance was indeed due to COVID or whether it was just an attempt to revisit commercial terms that they didn't like. We had prepayments that were under negotiation as the COVID crisis advanced. So were we still prepared to agree to the terms that we had been in the term sheet stage, or did we need to revisit that and amend that? We had renewals of existing prepayments. Did we want to go ahead with a renewal? And we had new prepayments being put on the table as counterparties looked for financing. Were we prepared to consider those, and if so, on what terms? From a corporate financing perspective, you may have seen that some of the banks have been withdrawing from commodity trade finance. But for Trafigura, actually, this was a record year for our European revolving credit facility. So in the midst of the COVID crisis, we were also renewing our 1.98 billion 365-day revolving credit facility. So that took time too. And we also had, as some of you may have seen in the press, requests from certain of our lenders to pay a COVID premium due to the cost of financing issues they were facing and the low interest rates. Now, I can't comment on whether or not we were prepared to agree those, but we did have to consider those requests from our relationship banks. You know, were we prepared to offer this at all? If so, under what terms, for what period, how much should that premium be? And also, you know, wider questions of how does that impact our relationship with this bank? Does it impact on any other financing? Can we do this without breaching other provisions of the financing documents in question? And again, that took a lot of time, a lot of liaison with the external firms who were working for on that to reach a resolution and make a decision on that. We also had the consideration of what to do with our industrial assets. Many of those have financing. Many of those experienced shutdowns or other difficulties due to the COVID crisis. Could they meet their amortization or repayment obligations under those facilities? And if that was going to prove difficult, you know, could we sit down with the banks and have a discussion? So there were discussions with some of our financing banks. Then we had to think about how do we document that? What should the terms of that be? And that took up a huge amount of time as well. For example, where we had a joint venture, then it wasn't just a Trafigura decision. We'd also have to discuss that with our joint venture partners. So a huge amount of collaboration and communication needed in circumstances where it perhaps was not as easy as it usually would be. So turning to my final slide, the future. Well, there's a question mark for a reason. I wish I knew. We are here in Geneva, at least, back in the office, albeit on a rota system. And it's lovely to be back. It's lovely to see our colleagues. It's really nice to have those informal chats again. I don't think any of us is sure how long that will be for. Everyone here in Europe, I think, is questioning what the winter will bring, whether there'll be a rise in rates. But it is nice to be back. And in terms of insights, I think it's given us a huge confidence in our ability to deal with the uncertainty that has been and I'm quite sure is to come. And the main takeaway I think that we've given to our clients is get clear wording, and please make sure you have a signed binding contract, because that makes our lives an awful lot easier. Thank you very much for listening, and look forward to your questions at the end of the talk.
Thank you very much, Katie. That was extremely interesting. I like the picture of you in your A&E triage doctor role, telling one trader you'll have to wait and seeing somebody else first. And I think also what's really interesting that came up in a lot of the work that I've been doing in COVID is the before and after. What do you do with the clauses for new contracts? And how do you stop people using clauses which they've been using in previous contracts and thinking they're still going to do the same thing, and they're not. So that's very interesting. Thank you very much indeed. We're going to change focus now in our next talk to consider the perennial and pressing challenges of environmental issues and environmental claims in the light of recent developments and trends. Because it's tempting, as I said at the beginning, to forget under the burden of COVID-19 of all of the previous problems that we've been dealing with before February and March of this year. And we're very lucky to have Russell King, Senior Legal Counsel of RWE Supply and Trading, to address us on the current crop of environmental issues facing the commodity trading line. And this is a particularly interesting topic because Russell is going to deal with aspects of contractual solutions to environmental issues that face the commodities trading line in drying up his contracts and in contract maintenance. And he's going to be covering, among other things, 4 topics: provenance of commodity and how that's dealt with in environmental and legal protections, compliance with environmental requirements and regulations, control over environmental issues, a very difficult topic if you're somewhere in the middle of a chain or somewhere at the end of a chain when you've got no control over anything, and Russell will be touching on that. And then liability when, as sometimes happens, it all goes terribly wrong. PCCL, I think, Russell, you've said in your notes, which was very helpful, sent me. I haven't been able to think of an acronym either, so I'll see whether you've now been able to come up with one. Over to you.
Thank you, Simon. I'm very conscious of the fact that the title of today's event includes the word disputes. But as I spent my whole career before moving in-house as a non-contentious, or as one of my colleagues is fond of saying about me, not a proper lawyer, I thought it would be safer for me to focus on giving some commercial context to issues that, if they do turn contentious, are about much more than financial loss. When Gaurav asked me if I would be involved in this event, he suggested that I chose a topic that was topical and of particular concern to an in-house energy lawyer. Katie had obviously already chosen the most topical of topical issues. So I thought I would speak, as Simon says, about one of the 3 perennial concerns that keep the average commodities trading lawyer up at night. 2 of those, anti-corruption and sanctions, have already been spoken about at previous Quadrant events. So I'm going to give a brief run through of our contractual preoccupations under the broad umbrella of environmental protection, which will lead nicely onto Gaurav's talk on environmental disputes, I think. It is, of course, a huge topic and impossible to do anything other than scratch the surface in the time that I have available today. So my focus will be on the wider context rather than the details, and to answer the question in the title of my talk, why it matters to the commodity trading lawyer. Now, it should be taken as a given here that from a personal perspective, we all care about protecting the environment. So the question is an objective, professional one. Why does it matter so much to protect the interests of the commodity traders that we advise and the wider group that we're a part of? I think it's fair to say that environmental protection is a concern for most businesses in the developed world now, particularly those that have any kind of public-facing aspect. Indeed, all directors of English companies are obliged by the Companies Act to have regard to, among other things, the impact of the company's operations on the community and the environment. In addition to this, the Non-Financial Reporting Directive of the EU requires certain companies to publish a report on the policies they implement on a number of topics, including environmental protection. The directive works on a so-called double materiality principle, which means that companies should not only disclose how sustainability issues may affect the company, but also how the company affects society and the environment. As I'm sure you'll all be aware, in addition to these broad requirements, there are numerous measures targeting businesses in the energy sector, from wide-ranging reporting obligations and financial incentives or disincentives under the EU emissions trading scheme, for example, to the gradual reduction and ultimate prohibition of traditional fuels, like the recently passed German coal phase-out legislation. The RWE Group, as one of Europe's largest utilities over the last 100 years, is obviously front and centre at this constantly evolving legislative landscape, and so it's subject to ever-increasing pressure from regulators, investors, NGOs, and sections of the general public. It's in this context that the RWE Group has recently announced a commitment to make its energy generation climate neutral by 2040, well ahead of the EU's 2050 target for net zero greenhouse gas emissions. Although the 2040 target and the wider pressures on large companies, particularly those in the energy sector, are essential background, they're not really necessarily front and centre of my day-to-day work. And I'd certainly not profess to be an expert on any of those topics. I work for RWE Supply and Trading, or RWest, which in addition to being key to the core business of the group, energy generation, also operates as a trader in its own right, including the trading and shipping of physical commodities, principally coal, LNG, biomass, and iron ore. Therefore, much of the time we at RWest are, from a commercial and a legal perspective, as concerned about the needs of the buyers, transporters, and end users of the commodities that we trade as our own requirements and aspirations. So, on top of the wider issues mentioned earlier, it's key for us to ensure that the product being traded complies with environmental laws that go directly to the value and tradability of the commodity, and also that its extraction, processing, and transportation does not cause us as buyer, seller, or user of the commodity to be in breach of law. As Simon says, as I see it, environmental provisions in contracts can be broken down into 4 broad topics, which sadly I've not, Simon, been able to come up with a better acronym than PCCL, so we'll go with that for now. And I'll look at each of these in turn very quickly. Firstly, as far as provenance is concerned, the issue is most evident in our biomass sale and purchase contracts, with pages normally taken up by the various sustainability rules that wood pellets or waste wood must comply with in order to attract subsidies, or in some cases to be burned at all in the destination country. For the RWE Group power plants in the Netherlands, for example, all biomass must as a minimum comply with the SDE Plus requirements, which provides that its use must lead to a substantial reduction in greenhouse gas emissions as compared to fossil fuels. The assessment of whether this is the case involves not only an analysis of the chemical contents of the fuel itself, but also the forest management practices of the producer, requiring substantial cooperation throughout the supply chain, which obviously needs to be contractualised. The principles of the Renewables Obligation Order in the UK are similar, looking not only at the life cycle greenhouse gas emissions of the biomass, but also considering the land from which the biomass is sourced. In our long-term contracts, we obviously seek as much flexibility as possible to cope with legislative changes and to require the sellers and the biomass that they are providing to comply with as broad a range of legislation as possible to increase tradability. I think I should point out here that we at RWE normally go above and beyond minimum legal requirements. In the case of biomass, for example, requiring Forest Stewardship Council certification, or another example as far as our coal trading business is concerned, we are a member of Better Coal, which was founded in 2012 by a group of major European coal buyers, including RWE, to promote continuous improvement of sustainability performance in supply chains. With respect to the second topic, compliance with laws is obviously a key aspect of any sophisticated contract, but it can be particularly complicated in the context of physical commodities, as a party will normally not just be required to comply with laws applicable to it, but will also include laws of the other party to the contract, and frequently third parties up and down the sale or transportation chain. The aforementioned provenance issues are key here too, but perhaps more important, legally speaking, is identifying which laws are relevant and apportioning responsibility for ensuring that the cargo and the vessel carrying it does not breach those laws, as mere presence in a sale or chartering chain, or appearing as shipper or receiver on a bill of lading, could open the commodity trader up to liability, or at least alleged liability. As with provenance, change in law needs to be carefully considered to establish which party has to procure compliance and how costs should be apportioned. The best recent example of this for our West, and I'm sure for Katy as well at Trafigura, was perhaps the IMO's 3% reduction in the sulfur cap for vessel fuels in 2020. We operate a large fleet of dry bulk and LNG carriers, principally on time charter. So although we do not physically control the ships, we are responsible for the purchase of bunkers, whether directly or through subcharterers, leading to a complex web of contractual rights and obligations, particularly during the transition phase. The issue of maritime emissions is actually very topical in the EU this week, with the European Parliament voting this Tuesday to include maritime emissions in the EU emissions trading scheme from January 2022, which in itself is likely to be far more difficult to negotiate from a contractual and operational standpoint than even the fuel sulfur cap. The third topic is control. Now we, and I'm talking here about the day-to-day commodity trading work of our West, not the wider group, do not dig things out of the ground, chop things down, refine or process things, or own the assets that transport those things. Accordingly, in most cases, we have to rely solely on the words of the contracts to which we're a party to, both to establish provenance and ensure compliance, but also to allow us to monitor whether relevant laws are being complied with, and in certain cases, take action if they're not. Here, action is normally negative, such as having a right to reject the commodity or not pay hire for the vessel, as taking positive steps to intervene in an alleged breach of law could put us in the crosshairs of the relevant legislative body. Perhaps here the word control is the best explanation of why environmental issues are so concerning for us in-house commodity trading lawyers. I think it's fair to say that a desire to be in control is a typical personality trait of a person that chooses a career in the law. And in this context, as well as a lack of physical control, the laws that are relevant to the dispute, or at least the loss, are unlikely to be the laws on which one is qualified to advise. As an aside here, I would advise you not to Google personality traits of a lawyer. I did so last night, and it appears that the internet doesn't like lawyers very much. Finally, and I recognise that I'm pointing out the obvious here, we do what we can to establish which party is liable for breach. So it's clear who is responsible for dealing with authorities, paying for the costs of remediation, settling any resulting fines, and compensating for other losses. The financial consequences of environmental damage can, of course, be huge, particularly when considering water pollution caused by a vessel that we're operating or that is carrying a cargo that we have an interest in. As a member of a high-profile group with a large balance sheet in an industry populated by offshore SPVs, it's fair to say that we would attract attention even in no way culpable for the issue. As a result, great focus is put on us apportioning liability appropriately and ensuring that the liable party has the technical capability and, most importantly, the financial strength, whether directly or through insurance coverage, to respond to any incident. So apologies that this has been such a whistle-stop tour of a hugely complicated and multifaceted topic, but if nothing else, I hope it's given some insight to those in private practice on what goes on in the mind of an in-house commodity trading lawyer, and has had my in-house colleagues nodding broadly in agreement. Although given that I'm sat in my dining room looking at a bookcase, I guess I'm never going to know.
Russell, I'm sure they're all nodding furiously, he said loyally, just after they've Googled personality traits of a lawyer. And I'm sure we could all come up with a few of those. That's extremely interesting. Thank you very much indeed. And I think it teaches us the need to future-proof contracts in terms of trying to guess what's coming down the line. You've mentioned sulfur emissions for bunkers is a good example. And trying to build into our contracts a fair allocation, or at least what we think is a fair allocation of responsibility for things that may be happening in the future. And it's environmental issues, it's going to be more and more difficult, I think. Following on the environmental theme, our third speaker is Gaurav Sharma, with a long and impressive background as an international dispute specialist. Previously in-house, senior legal counsel with Shell. Shell is a university, I think, in-house counsel. And then with 3 Crowns, and now very happily, I'm glad to say, he's with us here at Quadrant Chambers, tipped in legal directories as a future leader, rising star, new generation lawyer. Having had the privilege of working with him, those are all compliments that I can heartily and sincerely endorse. He follows on from Russell, and he's going to consider the particular place of environmental claims in international arbitration, both at the contractual level and at the international law level, so ordinary contractual disputes, and then investment treaty disputes. And he's going to explain to us his view that there is going to be an increasingly central role in both the contractual and the international law aspects of environmental claims. Gaurav.
Thanks, Simon, for that introduction, and good morning, everybody. Good to be speaking to you today. It was certainly interesting to hear from Katy and Russell about the challenges that businesses in the midstream have been facing in recent months and years. And perhaps it's unsurprising that those challenges are very commercial in their nature, given the nature of the trading and commodities sector of the energy industry. As Simon says, I'm going to be talking about the upstream part of the industry today, the value chain. That is the part, for those of you who are less familiar with it, where oil, gas and other natural resources are developed and produced. I'll put up a quick, the one slide that I have today, I'm going to put up right now. The 4 things that I'm going to be talking about, I think you can see that now. I'll start by talking about the foundational contracts and law behind upstream relationships, before looking at the sorts of operational disputes that we've historically seen coming out of those legal instruments. And then I'll focus a little bit on the shift towards environmental disputes that we've seen over the last few years, before concluding with a bit of crystal ball gazing, thinking about what the future holds and speculating wildly about that. So the first thing I should say is that the upstream is not an uncommercial place. It certainly is commercial, but the focus is not so much on buying and selling as it is in other parts of the value chain. It's much more on the long-term cooperation and relational aspects of the relations between stakeholders, ensuring that there's a mutually beneficial economic outcome between them. So who are the stakeholders? Well, on the one hand, you've got producers or consortiums of producers who bring the technological expertise and experience and the financial capacity to develop upstream production operations. Typically, they're known in the contract as the contractor. And then on the other hand, on the other side, you've got the host state or the host state government who enter into contracts with the contractor. And those are the two sides. And those are usually 20, 25, 30-year contracts for production operations in a license area. So it's very important that the relationship gets off to a good start and has a solid basis to proceed on. And there are certain foundational contracts that govern that relationship. The first of those is the production sharing contract. There are many forms that this can take, but fundamentally what that does is set out any minimum commitment that a producer should have to the field development project in the early years. But more importantly, probably, is the aspect of sharing, of regulating how income derived from the natural resources that are extracted will be apportioned between the contractor and the host state. The other major foundational contract is the joint operating agreement. And the key thing that that achieves is to designate who the operator is and what their day-to-day responsibilities are when it comes to production and exploration activities. But it also governs other financial arrangements such as cash calls, contributions, issues like that from non-operators, including the host state, if it's a party to it. Now, in addition to those contracts, again, as Simon says, there are international law instruments that very often play a role in the relationship as well. Typically, these would be in the form of investment treaties, multilateral or bilateral ones, which provide firstly for a minimum standard of treatment by the host state of the investor and their investment, the foreign investor. And secondly, provide for recourse to neutral dispute resolution, usually arbitration in the event of an alleged breach of one of the substantive obligations. So those are the contracts, that's the law. Moving on to the second part of the presentation, what are the operational disputes that we've seen historically arising over the years? Well, I think the main ones, the main focus of the disputes has been economic, perhaps unsurprisingly, but that I would say has been the main trend. Under contracts, for example, I think the sorts of disputes that you might typically see or have seen involve issues such as work programs and budgets. That is to say, every year you would design a budget and a program for the development of the field that may or may not include drilling of new wells, for example. It may involve maintenance or overhauling certain aspects of the project. It could involve any sort of work, but that's what the work program and budget will provide for. And you can imagine that there are different perspectives that are taken on what kind of expenditure should be included from one year to the next, whether there should be an emphasis on production or on maintenance, for example. And you might look back at the end of the year and say, well, with the benefit of hindsight, should we have done X or Y, or should decisions have been taken differently in the course of the year, and expenditure have been done differently as well. Now, typically those things are regulated by the contract, by management committees, etc., and operating committees, but there are often residual and derivative claims that can arise under the production sharing contracts in relation to that expenditure. Similarly, another category of claim under the contracts that you often see are cost recovery claims. I'm sure many people who have tuned in today have spent many years of their lives involved in those sorts of disputes. But they typically involve these huge reservoir, if you'll excuse the pun, of receipts and expenses that are incurred by contractors as they finance the development of the project in advance, and then claim back the cost of those things through the first portion of oil or gas, whatever resource it is, to be distributed to the parties in recompense. Now, these things, there are enormous volumes of receipts that need to be audited, and that creates a backlog over many years worth many millions of dollars, hundreds of millions of dollars, billions in many cases, depending on the size of the project, over many years. And again, it has a huge effect on the distribution of profit, oil or gas or whatever resource it is, that's available to the parties each year. So you can see why there's a huge interest in those sorts of disputes and regulating them and sorting them out in so far as all stakeholders are concerned. What about the investment treaties? Well, here I think historically you've seen disputes that involve tax and fiscal incentives. On the one hand, the withdrawal of fiscal incentives, for example, in the case of Nigerian LNG, NLNG, several years over the last sort of decade or so, there have been threats at various times by potential incoming governments to repeal fiscal incentives worth hundreds of millions of dollars a year in tax duties, tax exemptions, customs exemptions, which have drawn the ire of NLNG and led to threats of treaty arbitration. But the imposition of new duties as well is a big issue. A good example of that, an interesting example, is the Law 42 example in Ecuador, where there was a so-called windfall profits tax of 99% to be levied by Ecuador above profits, above a certain threshold, to be fair, due to unexpectedly high oil prices. So it was a way of dealing with a new event, as it were. That led to treaty arbitrations with differing outcomes for Perenco, Burlington, Occidental Petroleum over the years. So that's tax disputes, fiscal issues. The other big thing that you might have seen in investment treaty arbitrations over the years is just outright taking of the investment, expropriation. Many examples abound again in South America. You've got Venezuelan cases, Ecuador as well, Bolivia. But an example that's perhaps close to home for those of us in Europe anyway is the recent UCOS award in 2014 anyway, of the taking of production facilities by the state and transferring them to its state-owned enterprise over time. So those are the sorts of issues we've typically seen in the contracts and investment treaties over the years in the upstream sector. That brings me to the third part of the discussion on environmental disputes. I think that what we will continue to see those operational and economic disputes in the years to come. But what we've seen recently is that they've been overlaid by a third and new species of issue, which is environmental disputes, which often become the center of gravity in any particular arbitration because, to an extent, of the novelty behind them, the newness of those sorts of claims, but also the fact that they generate huge amounts of evidence that need to be reviewed in terms of environmental impact and modeling and damage allegations, as well as the causal link between conduct on the one hand and damage on the other. Now, of course, the contracts have always contained provisions to do with preventing environmental pollution and damage for decades, since PSAs and production sharing agreements have existed. So what has changed? Well, I would suggest that there is a greater emphasis on other aspects of contractual relations. Specifically, I would note the emphasis on good oil field practice and the requirement in any upstream contracts for a contractor or operator to conduct petroleum operations in accordance with good oil field practice. There usually is no definition for what that means. So it's a matter of evidence or expert evidence in any given time or place what that definition means. And I would suggest that the reason why we're seeing an emphasis on claims based on good oil field practice these days is because it allows a host state, typically claiming under the contract, to make the connection between environmental damage on the one hand and the conduct of a contractor falling below a particular standard on the other. If you try to drill down, again, excusing the pun, on what good oil field practice actually means, well, I think you would find an array of definitions proposed, but there's general consensus that it would involve safe and efficient operations. And arguably that includes the need to adopt measures that protect the environment based on latest practices known to science in the upstream industry. So when you combine those advancements in technology, that includes as well the ability to litigate and arbitrate matters with models, new modeling techniques that are available and more accessible than they've ever been, computer modeling of the environmental impact of operations, together with a greater sensitivity, I think, at large, of the need to safeguard the environment. There's perhaps a clearer path today than there ever has been to seeing these claims appear in contractual disputes under PSAs and JOAs. What sort of claims are we talking about then? Under contracts, I would say claims that I've been involved in, I think we see quite a lot, involve drilling claims. Have the wells in question and the wellheads been drilled and cased properly, or are there potential leaks? Are there issues, historical ones, that may relate to wells that were drilled many years or decades ago? Are there issues that arise there that impact aquifers, water tables, flora, fauna, etc.? Local communities and livelihoods are at stake, so it's a big issue. Another category of contractual claim that you might come across that I've seen increasingly as well are flaring issues. Again, flaring, we're talking about the burning off in oil and gas operations, in particular of waste gases, which is a common occurrence. It's usually subject to very strict permitting requirements, but I think we see increasingly claims brought by host states and governments based on those flaring provisions, where they're, should we say, more strictly enforced by the states than they perhaps ever have been. And that could be for a variety of reasons: concerns about environmental issues or contractual issues more generally. So far as treaty claims are concerned, well, I think the interesting development here is that we see environmental issues placed both at the center of defenses that are mounted by states to claims against them, as well as in the context of counterclaims that they're making against investors increasingly where the provisions of the relevant treaty allow. So an example of the former that is used as a defense is where, for example, a state might require an environmental impact assessment to be conducted before operations can continue. An example of this is Bilcon in Canada, an NAFTA case of 2015. I won't go into the detail, but basically the investor Bilcon was pretty aggrieved when after sinking tens of millions, hundreds of millions of dollars into the project involved, it was told that it couldn't go ahead because of the environmental concerns that had been raised by an EIA. Contentious issue, and there was a dissenting award or opinion issued there in that case. So far as the latter category are concerned, that is counterclaims by states, I think we've seen a recent rise in these over the years. In 2017, we saw Besa in Argentina and Avon in Costa Rica. These are claims relating to water and sanitary facilities being provided, as well as, in the case of Avon, hotel and property resorts being developed over wetlands. So not quite the upstream oil and gas sector, but in upstream oil and gas, I think a good example is the Burlington and Ecuador counterclaims, where Ecuador sought recompense for environmental damage and was awarded $4 million for pollution and contamination resulting from Burlington's activities following site visits and a heavy evidential exercise on the environmental damage. So almost done then. That brings me to the final part of the presentation. What does the future hold? Very briefly, I think that we'll see an increasing emphasis on environmental claims as scientific knowledge and awareness increases, and the public sensitivity to the threat that can be caused by contamination or global warming more generally brings. I think specifically on the contractual side, we'll see more claims at the end of production sharing contracts. As they come to an end, we'll see an account taken, I think, by states of whether they can bring historical contamination claims that they might not have known about before, or whether those might be time barred. And in the treaty space, I think that we'll see that tension between a host state's right to regulate in the environmental area and matters of public policy versus an investor's expectations that it will be allowed to continue to invest and develop a project. I think that will come into sharper and sharper focus as we go on. And the one thing that I think we'll specifically see in the upstream sector is disputes relating to tight gas, hydraulic fracturing, where the state of knowledge is less advanced than it is in other areas. I think we'll see some interesting disputes coming up there, both on the contractual side and the investment treaty side. So that is it.
Thank you very much, Gaurav. That's very interesting indeed, and I'm particularly interested in the long-running debate, especially with experts, about what good oil field practice means and how, as it's such a broad and church and flexible concept, it's moved on really from doing it in a proper way, casing the well or whatever it is, in a proper technical way, in accordance with proper modern technical standards, into a standard which allows people to argue, well, not only should we do it all properly, but you've got to observe best practice environmentally generally. And that, I think, is where a lot of difficulties are going to be coming up. And I don't know whether, going back to points that previous speakers have made, one ought to be trying to address purely environmental concerns by specific wordings and not leave it to be dealt with by portmanteau terms like good oil field practice. But thank you very much indeed. Well, we end up running slightly late, but given the fact I'm pleased to say, or not pleased to say, although we have 204 speakers, we only have 4 questions, and they're all for Katy, so Katy, brace yourself. Don't worry, I shall spread them about fairly. We end up by looking at upstream disputes and current trends in such disputes. And so we come back in a way full circle to the events of 2020 and the effects of the drastic reduction in global energy demand and the collapse of energy prices, particularly oil price, in 2020. And whether we're in a different place in 2020 and after 2020 from where we were with the previous collapses of 2018 and 2014. And there's no one better to look into the crystal ball and tell us what she sees than Louise Woods of Vinson Elkins, highly regarded partner and specialist in international disputes, highly ranked in Legal 500's international arbitration section, and described very succinctly as excellent lawyer and very sharp. Well, and that's certainly looking at the notes that I've already seen from her talk, what we're going to be getting. And Louise is going to tell us what she thinks the post-2020 world is going to look like in terms of upstream disputes, and to consider a particularly interesting possible interrelationship between conventional arbitration proceedings and parallel insolvency proceedings. So over to you, Louise. Thank you very much.
Well, good morning, everyone, and thank you all for joining us today. I'd also like to thank Quadrant for having me, and in particular Sarah Longdon, who has worked tirelessly behind the scenes to put today's event together. As the title suggests, I'm going to spend a little over 10 minutes talking about current trends in upstream disputes. And I'm going to start by setting the scene with a quick overview of what the landscape looks like today, and I'm going to compare that very briefly to what we saw in 2008 and 2014 and 15. Then I will take a closer look at the types of disputes that we are seeing right now and the things I predict we'll see more of in 2021. And finally, I will consider the increasingly relevant interplay between international arbitration and insolvency proceedings. So, what does the upstream market look like today? Drastic reductions in both global energy demand and price have led, unsurprisingly, to a low cash environment that looks set to continue for quite some time. Recently, global oil supply rose by 1.1 million barrels a day in August as OPEC plus cuts eased, but was down 9.3 million barrels a day on a year ago. Production in the United States fell by 0.4 million barrels a day as Hurricane Laura forced precautionary shut-ins, and total non-OPEC supply is expected to drop by 2.6 million barrels a day in 2020, before posting a modest recovery next year. In addition, global benchmark Brent crude dropped below $40 a barrel last week for the first time since June. Before we go ahead and consider the ramifications of the current state of the oil market on disputes, I want to take a quick trip back in time to look at the 2008 and 2014-15 oil price crashes and the disputes that arose as a result. The 2008 global financial crisis was preceded by very high demand, which had contributed to a very rapid rise in oil prices. As a result of this, oil companies were desperate to secure equipment and services, and contractors were in very high demand. They had been able to secure long-term contracts on pretty favorable terms. And when the global financial crisis hit and oil companies felt the pinch, they did what they could to get out of these contracts. And we saw a lot of creative terminations for breach or alleged breach. Many of these were hotly contested by the contractors who often won. Now, if we fast forward to 2014, 2015, and we consider the environment the industry found itself in then, the preceding 4 years had represented a period of relative stability for the industry, with prices hovering around $110 a barrel, give or take $10, for that period. And that extended period of higher prices had encouraged production, and critically, by 2014, when some emerging economies' demand for oil slowed, supply exceeded demand. As a result, when the price fell dramatically again, the landscape was very different to what it was in 2008. A period of significant investment had meant an oversupply of rigs and other equipment, and there were too many contractors chasing work. In addition, as a result of what happened in 2008, oil companies had ensured their contracts were far less contractor-friendly this time around. This all contributed to a very different fallout. We saw fewer actual terminations and instead a focus on renegotiations, often against the backdrop of a threatened termination. Contractors were focused on maintaining long-term working relationships with operators and NOCs and were therefore more reluctant to fight. As a result, although there were plenty of disputes and contract renegotiations, we generally saw fewer full-blown arbitrations than in 2008. So what are we dealing with today? I spoke earlier about the current state of the oil market. The combined effects of overproduction and an unprecedented fall in global demand due to COVID-19 are undeniable. 2016 to 2020 saw a period of relative stability, but without the high prices that we saw in the run-up to the 2014 crash. There are generally fewer long-term multi-well contracts around today. So what trends are emerging in upstream disputes as a result, and how are these different from what we saw previously? I'm going to share with you what we as a firm are currently seeing, but to a large extent, I think it's too early to say definitively what upstream disputes will look like in 2021 and beyond. First, there appears to be a willingness to review, reassess, and renegotiate existing contracts in order to preserve longer-term relationships, somewhat similar to the fallout in 2014-15. That being said, where termination disputes are happening, they're often about survival, where parties, or at least one of them, have no option but to fight. We're also observing a very different way of looking at disputes. Some companies are increasingly focused on recoveries and viewing disputes as a way of generating revenue where operational revenue is reduced. Where there is a termination dispute, we've also seen more of a focus on mitigation, with arguments around what steps it's reasonable to take in the current climate. Looking specifically at disputes among joint venture partners, who are often struggling with cash flow, to continue operating, the focus at the moment has tended to be on costs and recoveries. We're seeing an increase in joint operations approvals disputes, for example, where the nature and extent of previously approved expenditures are being challenged, or where a non-operator challenges a contract on the basis that the requisite approval to enter into that contract had not been obtained. And that's particularly the case in the case of long-term contracts. I've also seen an increase in arguments around whether or not budget approvals were obtained. And also featuring heavily are disputes under the relevant accounting procedures annexed to joint operating agreements. We've observed an increase in the exercise by non-operators of their audit rights. And although accounting procedures are intended to give certainty when it comes to time limits, we're seeing an increase in disputes surrounding these time limits, and sometimes even the statutory time limits as well, as non-operators are seeking to claw back whatever value they can and ensure they're not being asked to bear the costs of expenses that don't properly sit within the joint operations. More generally, we're also seeing an increased scrutiny of joint account expenses, and traditional distinctions between direct and indirect charging are being blurred. Finally, I think we're likely to see an increase in cash call defaults, sometimes even deliberate, leading operators to exercise one of their available remedies. And I'd just note here that although the AIPN model form includes withering, buyout, and security interest as alternatives to the more draconian remedy of forfeiture, to my knowledge, there are no examples of these having been tested in court or arbitration to date. Now, what are we seeing on the contractor side? Unsurprisingly, we've seen a lot of force majeure notices, many of which are being challenged. More recently, as it's become clear that COVID-19 effects will not be short-lived, we're seeing terminations on the basis of either prolonged force majeure or for alleged breach. Combined with a reluctance to fight, many disputes are resulting, we're finding, in renegotiations where contractors appear willing to accept lower day rates, for example, to preserve the long-term relationship. That being said, in survival or bet the company situations, there may be no choice but to challenge the termination. And I think this is where we're going to see more arbitration litigation in future. On my next slide, I've included some examples of the types of disputes I think we're likely to see involving host states or governments. I don't think it's likely that we'll see a spate of oil companies suing governments unless they take the view that they no longer wish to continue doing business in those particular jurisdictions. But I do think we can expect cash-strapped governments to continue to squeeze oil companies to extract maximum value, as well as the usual contractual and fiscal measures such as increasingly front-loaded signing bonuses, increased tax authority probes, etc. We've seen several recent instances in which operators have been presented with revised terms on a take it or leave it basis by governments, which have resulted in spin-off disputes among joint venture partners themselves. And of course, there's been a lot of recent speculation as to whether we'll see a spate of investor state claims as a result of government measures taken in response to COVID-19. For example, either as breach of contractual obligations assumed by the host state through an umbrella clause in a bilateral or multilateral investment treaty, or directly for a breach of the treaty itself. And in this context, I think it's worth noting the increasing use of regulatory powers carve-outs in bilateral and multilateral investment agreements. And one such example, for example, is the Japan-Israel BIT 2017. But there are many, many more. And also, I'd just highlight the recent but heavily criticized Columbia Center for Sustainable Investment call for a moratorium on investor state claims during the pandemic. I'm going to spend my last few minutes reflecting on the increase in parallel insolvency and arbitration proceedings and their differing policy objectives. Whereas arbitration strives to uphold the arbitration agreement and promote certainty in commercial transactions, insolvency laws are designed to enable the reorganization of the debtor and, to the extent possible, where the debtor cannot be saved, equality of creditors and centralization of claims. Insolvency proceedings naturally can affect parties to arbitration at any time, And cross-border disputes involving multiple parties and multiple sets of proceedings can often result in inconsistent outcomes. Some jurisdictions view insolvency issues as procedural, others substantive, and some insolvency laws provide for an automatic stay of proceedings, although there is a debate as to whether that includes arbitration as well as court proceedings. In the US, for example, because of the automatic stay of all claims, a party seeking to commence arbitration against a debtor in a Chapter 11 bankruptcy proceeding must seek the leave of the US Bankruptcy Court. And in a typical operator-non-operator dispute, arbitration might be allowed to proceed, but it will depend on whether the matter in dispute between the parties is considered core for the purposes of US bankruptcy law. In the UK, we've seen the recent Corporate Insolvency and Governance Act, which entered into force earlier this year. And where a company enters into voluntary liquidation, there's no automatic stay of proceedings, although one might be obtained on application to the court. By contrast, when a company enters into an administration, it does benefit from a stay. The new Act, which came into force, I think, in June, introduces a standalone moratorium procedure, which is available to all companies with some limited exceptions, that can meet certain eligibility criteria. It applies initially for 20 days, but can be extended for a period of up to 1 year, during which time no legal process may be commenced or continued against the company. So this really does have the potential to impact upon threatened or ongoing arbitration proceedings. Clearly, when dealing with the types of high-value disputes that we see in the upstream industry, the interplay between insolvency and arbitration laws and procedures will have significant relevance. Some of the practical considerations that will be important to bear in mind include the priority that insolvency laws place on different types of debt, the seat of the arbitration, the potential enforcement issues down the line and the impact on likely recoveries, the location of insolvent parties' assets, and any interim and enforcement measures, such as security for costs orders and third-party debt orders that may be available depending on the seat of the arbitration. In the case of an insolvent respondent, however, tribunals might refuse to order security for costs security in relation for potential damages, as this could violate the principle that puts all creditors on equal footing, save for the existence of preferences. And I'd also just add that in relation to third-party debt orders, the recent case of Taurus and the State Oil Marketing Company of Iraq, in that case, the Supreme Court significantly expanded the scope of third-party debt orders to include funds due under letters of credit issued by a bank in England. So where might all this lead? It may be that we see an increase in early settlements rather than risk lengthy arbitration proceedings in the face of an insolvent respondent. This may inevitably result in a compromise in terms of the amount of any settlement. Conversely, where a respondent is not yet in an insolvency process, it might nonetheless be beneficial to proceed with arbitration. The final award will determine any dispute as to the existence or quantum of the sum due, to be relied upon as a claim in the bankruptcy proceedings. And finally, I expect we may see an uptick in the use of asset tracing companies and reliance on local insolvency counsel for advice where insolvency is perceived as a risk. In conclusion, I think it's clear that the landscape for upstream disputes is in a period of flux. Increasingly, disputes counsel will need to be agile and adaptable in the current remote working environment. I expect an increase in contract renegotiations, and where deals cannot be done and disputes go to arbitration or litigation, I anticipate a need to be more alive than ever to the potential for insolvency and to take steps to guard against those potential ramifications. Thank you.
Thank you very much indeed, Louise. That was an extremely interesting look into the crystal ball, and we'll only be able to tell in a few months' time whether you're right or not. I think we've got time for questions. We still have 166 people on, and so I'm now going to throw it open so everybody comes on the screen at the same time. And let's take the 4 questions which we have. As I say, they appear to be all to Katy, but that's not fair, so I'm going to spread them around a bit. But I will take the first question, which was addressed to Katy. And it's this: has Trafi's legal team had to look at many guarantee issues for demands brought on by COVID-19 related defaults, e.g. on demand versus performance guarantee issues?
Actually, not so much. Where we haven't had to look at that too much. We have had to look at the situation where a counterparty either threatens to default or looks like it might default, and what's the position if there is a guarantee. But in terms of actually claiming under them, we've generally tried to resolve it before it gets to that point. Obviously, in the context of Louise's discussion just now, if there was a fear that insolvency might be imminent, then that's something that we would look at. But generally, we've tried to resolve it without actually calling under a guarantee.
Okay, thank you. And the next question, I think I will put to Gaurav, which is, have any of the panel had any experience of virtual arbitration? I could answer that question myself, and I'm not going to. Gaurav.
I hear your answer, but I'll have a go first. I have had quite a bit in the context of adjudicatory proceedings as the adjudicator, but also the procedural hearings, which are actually, they have been frequently conducted virtually over the years anyway, in my experience, very often when the parties are all over the world. Probably more interesting is the conduct of substantive arbitration proceedings. I have had some experience of that as well. I find it's been fascinating. You and I, Simon, wrote an article at the beginning, I think, of the lockdown about the various things that parties are doing to try to, or can do, to try to adapt to the situation that we find ourselves in. And I have found that people have really embraced that. It's not always easy. It's not always obvious that you need to take a break in a hearing more frequently than you would if the hearing was in person, because it's quite tiring for parties to follow things, or for all participants to follow things over the course of a whole day. So you might shorten the day, you might adapt to the way that witnesses are being cross-examined, and I think what I've seen happen there is it's just greater scrutiny on the process, and actually being able to zoom out a little bit and make sure that the witness is put in the same scenario that they would be if they were sitting in a hearing room in person in the middle of the floor in front of a tribunal, making sure that there's nobody very clearly sitting to one side of them. I think safeguards like that have been particularly important to make sure that there's no obvious way of challenging an award based simply on the fact that the parties have had to adapt to doing the hearing virtually rather than in the comfort of a room. So I think those are my main observations.
I think when you and I wrote that article, we were looking at ourselves into a bit of a crystal ball. We were fantastically optimistic, it will all be doable. And in fact, it has been doable and is doable. I've done quite a number of arbitrations as counsel, big substantive ones, 5 days, 6, 7 days. I've done cases in commercial court as counsel, but also as a deputy high court judge. And I think the surprise that everybody's found, including international arbitrators who have been sort of harbingers of doom, is that it actually works pretty well. And provided you're commonsensical about the things like breaks, making sure the witness can be seen, so there's no possibility of being prompted with notes, and you've got a good provider of documents, because of the virtual document system, which most of us have been using for a couple of years now anyway, it actually is surprisingly effective and almost pleasant. I mean, you don't get the sort of buzz with the team afterwards or during the hearing, which is a big downside. Otherwise, I think it's working very well. So let me ask another question, and this one I think is now, I'm going to put this to Louise. This is a question I've had to grapple with on a number of occasions in the last few months. Louise, did you think that contracts for lower grade crude, priced with a discount rather than a premium, which generated a negative price in April, for instance, remained enforceable in terms of consideration? So this was that strange week or 10 days when suddenly the prices went negative, and different sections of different trading houses were taking different views as to what they wanted to do about it. And I gave advice to a number of parties, and I don't know whether anybody else did. But Louise, do you have a view on that, or are you able to express a view on that?
It's not actually something that I was required to look at the time, so I don't have any experience of dealing with that particular question myself. So you may be better placed to give us your thoughts on that. But before you do, I was just going to add on the the virtual arbitration point, it's something that I too, Gaurav and Simon, have had experience of pre-COVID. And I've seen work well. I mean, in one particular instance, we had a witness who was imprisoned in a Southeast Asian state and had to give evidence from the prison, for example. We've also had ones where we've had witnesses, the claimants, so our clients themselves, under house arrest in various jurisdictions and unable to travel to the hearing. And we've always found that it's worked well, provided people are prepared to be adaptable. I agree with the need for frequent breaks. And I think another thing that perhaps people don't really give account for it and warrant thinking about is the time zones, because when we travel to hearings and witnesses travel to hearings and parties, we always allow a day or two of acclimatization. And I found myself having to get up in the night to sort of dial into procedural conferences and so on, because we're trying to accommodate people across jurisdictions. And I think more sort of foresight and foreplanning needs to go into those types of things. But otherwise, I do think it works well. I think you need a WhatsApp or something similar for communications as well, that's separate to what's on screen. I think that's really important too.
Yeah, I think you're absolutely right about the flexibility of timing. And in the hearing I was doing in August, we had the president of the tribunal was based in Australia. Other witnesses were based in various places. And so rather than just stick with a traditional hearing day, we started at 8 and finished at 1. And it worked very well. And people have just got to get a bit more flexible. People think, oh, I've got to start at 10, we've got to sit until 4, or we've got to maintain the full hearing day. You don't need to maintain the full hearing day. You can have different hearing days of different durations. So on the consideration question, which we started with, I think I won't really give an answer, except to say I don't think I've ever seen a case work for total failure consideration. That's what my answer to that would be. And then one last question, I think. Katie, are you ready?
Can give it a try.
Sorry, you're batting these, but they all have your name on. So a question for Katie: do you find that counterparties are more willing to agree to foreseeable, or at least not wholly unforeseeable events, such as a COVID-19 outbreak or second wave, being expressly included in the definition of force majeure in contracts?
I mean, the problem with all of this is it depends. I mean, I think generally people are happier when it's something clear. So, for example, when we were looking at our COVID clause, or indeed our infectious diseases clause, we tried to tie it to something tangible. So it's a lot easier for everyone if it's not in someone's reason of opinion, but it's tied to something like, for example, the World Health Organization declaring something to be a pandemic. And I think as a lawyer, that's what you always want. You want to be able to say, well, I don't really want to be relying on whether another party thinks that they're going to be reasonably prevented by some possible government order, which may or may not be reasonable, or might be, not even a government order, but a port authority issuing something that isn't necessarily based on objective facts prevailing at a port at any given time. So from that perspective, I think, yes, generally there's a preference, certainly where the lawyers are involved, for there to be certainty and for it to be tied to specific events, or something that's that links to a directive of a recognised organisation. On the flip side of that, I would say that depending on which contract it is and the particular circumstances, usually traders want to have their cake and eat it. So what I'll get sometimes is, please can we have this clause that does precisely this in this situation? And then 6 months later, they come back to you and say, well, why did we agree this clause? And you say, well, that's because you wanted. So that's where we try and be the voice of reason, and at least kind of be a sounding board and say, well, okay, that works for you now, but is that going to work for you in 6 months' time if the environment changes? And that's generally the debate that we often have.
Yeah, it seems to me to be driven a lot by commercial considerations,
exactly,
and bargaining power. But I think certainly in terms of clauses I've been asked to look at, the requirement, everyone's requirement, is at least let it be certain, so we know whether the clause operates or not, without having to go into concepts like reasonableness and foreseeability and hinder or prevent. Let's get a firm framework that works. Because there are so many different regulations. I mean, look at what's happening in the United Kingdom. We don't know whether they're coming or going, whether you can travel somewhere or not travel somewhere. And I think contracting parties really need certainty rather than the old type of force majeure clause. Louise, have you got a view on that, or anybody else got a view on that before I wind it up? We've still got 140 minutes.
Yeah, I had a quick thought actually, and I don't know whether you found it too, Katie, but one of the troubles we've had, particularly in chartering, is that the existing standard clauses on things like infectious diseases are wholly inappropriate for something so widespread as COVID. So the BIMCO and Intertanko clauses were drafted based on, something like Ebola that's medically disastrous in all cases, but very much geographically limited. Whereas we found difficulty with the BIMCO clause that it essentially prevents or allows the master not to go anywhere that is affected by the disease, which at the moment is basically the whole world.
Yeah, no, it's exactly the same thing. I mean, we generally will look at BIMCO as a good starting point for obvious reasons, but whether or not that clause is wholly appropriate, and I mean, no one foresaw COVID, so of course there's no clause that's appropriate, and then that's why we ended up drafting COVID-related clauses specific for our charter parties and had that whole debate. But of course, everyone's doing the same thing. So then you end up with, do we put ours in or do we agree someone else's? And then that's a whole other negotiation. So it's been really interesting seeing how that plays out.
And Russell, have you got your own RWE COVID-19 clause?
We do, yeah. And again, a bit like Katie, we adapt it as to whether we're owning or chartering in some cases. But I think we try to be fair on it. But I think maybe just to connect mine and Katie's talk, I think one of the positive aspects of COVID I've found on my clients is that, unlike my own children who have had to rely on me to educate them for the last few months, I feel that the traders have learned quite a bit about having to think about the future. And, I think with environmental issues as well as things like diseases, they've realized not just thinking of the here and now it is not necessarily going to protect them if something like this happens again, which it may well do.
Yeah, and I think another aspect of COVID-19 with virtual hearings has also been, I've had it in two examples, where the trader can actually now drop into the hearing. And before, they're usually too busy, they never come to the arbitration, they're trading to leave or whatever it is. And there's a strange mystery about, why does it all take so long? Why do we need to do this? Why do we need to do that? And what I've actually found, it's taking place with court hearings rather than arbitrations, is that the traders can actually be there whenever they want to and see what's happening. And I think they found that very, very interesting and informative. I don't know, Katie, whether you've come across that, or Louise, you've come across that.
Yeah, I've got a hearing at the Court of Appeal in a few weeks, and they've given us the option of a sort of hybrid. So counsel will appear in person at the ICJ, but client representatives on the commercial side who wouldn't normally travel down for the hearing will be able to dial in remotely and follow the whole thing. So I do think we're going to see an increase in sort of non-legal people sort of becoming involved in the process, and whether that's going to have an impact at the front end in terms of how they think about contracts and so on once they've seen the disputes play out will be interesting to see.
Very. Katie?
I've only had a procedural hearing so far, which was in arbitration, and what I did quite like about that was they could just dial in that case. They didn't even have to be present on a video conference, and it was, I think it was interesting for them to hear, how our counsel put the case, how the respondents' counsel put the case, what did that look like, what were submissions like, and see the process. So yeah, very useful from our side too. Okay, well,
I think we'll bring that to a close. Thank you all very much. Can I first of all thank our speakers, busy people who have given up their time to give us a fascinating insight into the legal and commercial issues arising out of 2020's events and current issues. And although we can't do it manually, I hope you'll all join with me in a very loud virtual round of applause for them. They've been really interesting talks and very well delivered. Thank you all very much. An equally big thank you to all of you who tuned in and are listening. Still 125 loyal people sitting in. We've had up to 209, I think. So that's very good. And I hope you found it all interesting and informative. There will be recordings of this, which will be available afterwards if you want to either distribute it. People who haven't been able to watch it, or you want to listen again to some particular aspect. And lastly, my thanks to Sarah Longdon, the indefatigable organizer of Quadrant Chambers events, who was able to cope with every and any problem in Zoom or anything else, even at 5 minutes to 11. The operation has been, as usual, seamless. Thank you very much. So a big thank you to my colleagues on the panel. A big thank you to you all, and I hope you have a very good day. Thank you very much for joining us.